This time, the Chair recognizes the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chair. Ms. LaFleur, if I understood your testimony earlier, and I wrote down part of it, but I don't want to put words in your mouth. Given the structure of the Clean Air Act that we have, the EPA, I think you said did a good job or something similar to that. I got it to that point and then I couldn't write fast enough. Is that an accurate statement of your opinion?
That's basically what I said. I said that there might be more. The question was, what's the most efficient way to regulate carbon?
Yes, ma'am.
I
I'm
said,
just
given
trying to
the authority they have, they built a lot
yes,
of
ma'am.
flexibility.
That wasn't my question. My
Yes.
question is that a statement of your opinion that the structure of the Clean Air Act that we have, under the structure that we currently have, the EPA did a good job in coming up with these regulations?
Yes.
And so then I would ask you to reconcile for me, when you take a look at Section 111 of the Clean Air Act, where in Section D it says the administrator shall prescribe regulations which shall establish a procedure under which each state shall submit to the administrator a plan which establishes standards of performance for the existing source for any air pollution for which air quality criteria have not been issued or which is not included on a list published under Section 108A, and the critical part, or emitted from a source category which is regulated under Section 112 or 112B. And how do you reconcile that with the fact that electric generation units are currently regulated under 112, and therefore the EPA does not appear to have authority under the Clean Air Act to propose the regulations which they've enacted, and what they're relying on is a Scrivener's error that took place in the redraft in, I believe, 1990, but in a case which I would cite for you all to go back and look at, and with your lawyers, in a case New Jersey versus EPA 517 F3rd 574 2008, it appears that the EPA acknowledged that they didn't have this authority, and the court ruled, accordingly, in view of the plain text and structure of Section 112, we grant the petitions and vacate the delisting rule, which was a previous lawsuit. This requires vacation of CAMR's regulations of both new and existing EGUs, electric generation units. EPA promulgated the CAMR regulations for existing EGUs under Section 111D, but under EPA's own interpretation of the section, it cannot be used to regulate sources listed under Section 112. So it's not just my reading, but apparently the EPA in a court case made that same reading, and then the EPA thus concedes that if EGUs remain listed under Section 112, as we hold they do, then CAMR regulations for existing sources must fail. So it would appear that the EPA is reaching way out, and under the existing law, I would submit they don't have the authority, and that they are asking for litigation. Doesn't that make your job harder in trying to figure out where you're going to go when the EPA is stretching the law so far that they disagree currently with the decision of the court that they conceded was the correct reading of the law as late as 2008?
Well,
yes or no?
The legality will be decided by the courts, but we're going to do our job to try to keep the lights on in the meantime.
And I appreciate that you all are going to try to keep the lights on, and that brings us to this whole pipeline issue. And I worry about the EPA and folks filing lawsuits on trying to lay down new pipeline to get it to the power sources, and all of a sudden we have EPA regulations coming in and saying to us, wait a minute, you can't put the pipeline there, or we have lawsuits that last longer. And Mr. Norris, you said earlier you were confident in the American innovations and so forth, and I am too. The problem is the EPA apparently is so confident they believe that we can get it done in 2 years. We know from the Department of Energy, and I sometimes wish that all of y'all would sit down and talk on a regular basis. The Department of Energy has told us that new clean coal technology will not be available for approximately 10 years, even if what we're working on now works. And I think there's some really exciting things. I love chemical looping, but we're looking at 10 years. I think with some money we might be able to shorten it to 7 years. But under these proposed regulations, assuming that they go into effect, the states have to come up with their plan. Even though they have 10 years to hit the target, their plan has to be completed within 1 year. That doesn't seem very reasonable to me. Do you believe that states really can come up with a plan, not knowing where the pipelines are going to be, not knowing what technologies are going to be available, that can hit all of these very rigorous standards, come up with the plan now for 10 years later?
I do.
Yes or no? Thank you. You do. All right. That being said, also I would point out that somebody said earlier, well, we only have 5 minutes, so I got to hurry. Get it all in. I got more than I can handle here. Somebody said earlier it's not the EPA regulations that are putting the coal-powered plants out of business. It's the price of natural gas. The problem is that coal and natural gas compete about even at $4 a unit. And for most of this year, it is true in the last week or so it has dropped back down under $4, but for most of 2014, the natural gas price has been over $4. And so if it's not the price, I would submit to you all, it must be EPA regulations, which are in fact killing jobs across this country. And we're doing it at a time when this country can't afford it. The people in my district can't afford it. The consumers are the families of the middle class America. We are the ones being hurt. It's great to have all these lofty ideas, but I don't see it working, and I fear that we're going to have rolling brownouts in the future, and I fear that you all are going to have a really tough job because of these EPA regulations. And with that, Mr. Chairman, I see my time is up, and I yield back.
This time I recognize the gentlelady from California, Ms. Capps, for 5 minutes.
Thank you, Mr.